Good afternoon. My name is David Callahan. I'm the chair of the Readers Course Committee of our bar. I'm reminded to tell you that this evening's entertainment is being podcast, so if you have a question at some stage when it comes time for questions and you don't need to identify yourself, I think is the point I'm asked to make. Tonight you will hear from our Honorary Secretary, Bree Canusta, regarding the process of the November bar exam, and then from Dr. Linda Haller, who is our Chief Examiner, and she will outline the structure of the exam, some sample questions and recommended preparation. Also on the panel we have Jacqueline Stone on the far right, and expect shortly to have Dr. Suzanne McNichol, who is the chair of the Exam Entrance Working Group. The rationale for the exam is to set a base level of knowledge for all readers. As a result of it, we reduced the length of the course from 3 months to basically 2 months. And the aim of it is to enable us to commence the course teaching at a higher level than might otherwise be the case. There are 4 areas that are covered in the exam: civil procedure, criminal procedure, evidence, and ethics. And what we expect in the exam is a demonstration of the level of knowledge of a competent barrister in each of those 4 areas. As I said before, we'll give you time for questions a little bit later. And of course, beyond the exam, assuming that you pass and satisfy the application criteria, the bar course itself runs for roughly 8 weeks, I think, and in the forthcoming course, the teachers include people such as the Honourable Justice Payne of the High Court, the Honourable Justices Harper and Maxwell from our Court of Appeal, Justices Jack Forrest, Hollingworth, Guard and Whelan from the Supreme Court, Justice Middleton of the Federal Court, and a number of retired judges, including the Honourable Ray Finkelstein, the Honourable Peter Heery, and the Honourable David Byrne. And there is, of course, also an array of silks and juniors who form an extremely important part of the course. Practical matters, you need to, if you intend to sit the November 15 exam, you need to apply by 5 p.m. on Monday 15 October and pay a fee of $350. The 15 November exam will be held in 2 places, depending on numbers, in this room and at the Monash Law School next door. And we will post the results of the exam just as soon as possible. I don't want to fudge the question of when that would be, but we would think it's surprising that we couldn't do it, to use double negative, before the Christmas vacation. If you do get an offer and you wish to take it up, the full course fee must be paid within a week of the offer, and then interviews with our Honorary Secretaries, Bree and Rob Craig, who's over there, will shortly follow. The course itself will commence on 18 March. Is it possible to just see a show of hands for those who are contemplating or interested in or vaguely thinking about the November exam as opposed to the next exam next year? Thank you. For those who didn't put their hands up, the next exam information session will be on 26th February next year, and the next exam for the September 13 course will be on the 22nd of May next year. I'm also reminded to tell you that if any circumstance exists or arises which would require you to request special consideration, then you should request it just as soon as you are aware of that circumstance. So that's enough from me. I hand over now to Bree Canuska to address you.
Thanks, David. So as David said, once you pass the bar exam, you'll have an interview either with me or the Assistant Honorary Secretary, Robert Gray, sitting over there. And the interviews are quite informal. They only take around 15 minutes and they're usually scheduled over 1 or 2 days. Given that the exam is going to be in November, it probably means that they'll be taking place in around the Christmas period in January 2013. Now, prior to the interview, you will have completed an application to sign the role of counsel and also a questionnaire, and you'll bring that with you to the interview. It's important to bring it with you because the application requires you to make disclosures in it. And the disclosures are important for 2 reasons. One, they may be relevant to your ability to actually undertake the Bar Readers Course. And secondly, it might affect the Bar Council's decision as to whether or not you're given a practicing certificate at the completion of the course. So it's important to know that in passing the exam and in submitting an application and even in completing the course, there's no guarantee of a practicing certificate. Of course, it's rare that a practicing certificate is not given, and rarer that conditions are placed on the practicing certificate, but you should be aware that depending on what disclosure you have or that you need to make, that there is a risk that you could be refused a practicing certificate at the completion of the course. So make the disclosures early and make them in the application, and Rob and I can deal with them and they can be referred to the relevant people at that time. So the best practice is just to be full and frank. In terms of what to disclose, in the application it's set out a number of specific things. And the obvious ones are criminal offences in Australia or in any other country, disqualification from managing or being involved in a corporation, any orders under the Bankruptcy Act, insolvency, any complaint made to any professional body or association, and that includes both legal bodies and associations, but also other associations outside of your legal practice. And you also have to disclose any fact or matter which might tend to show you're not of good character or not of sound mind or not a suitable person. So it's really quite broad, and you really need to turn your mind to whether or not there's anything that fits within that category. So that's in the application form. Again, in the interview, Rob or I will ask you whether you've made all the necessary disclosures, and again say, is there anything that you need to disclose that isn't included in the application? And again, err on the side of over-disclosure. Some things that people don't think about in terms of disclosure is things like medical conditions which might affect your ability to practice. It might not formally fall within any of the categories that I've mentioned, but it might be relevant, so that's something also to consider. In terms of a guide about what to disclose, the Legal Services Board has a fit and proper person policy that's been provided and copied out there that you can get a copy of, and that's a very good guide in terms of what the Legal Services Board looks for when people are renewing practicing certificates, and the same principles should apply when you're making disclosures in terms of coming to the bar. Rob and I are often asked about traffic offences and whether or not they have to be disclosed, and that really depends on how many and how frequently you have traffic offences. So if unsure, just disclose and we can give you guidelines as to whether or not it's relevant. And probably the easiest thing is to go and get a printout from Vic Roads, and that will have a record of how many traffic offences you have and how frequently, etc. So probably best to let us know about those. At the interview, once you've made all the disclosures, if you have any, you'll be asked to give an undertaking to Rob or I, and that is to let us know if anything arises after the interview. we'll give you a copy of that undertaking, but that will apply to the period from December, January, February, March until you commence the Bar Readers Course, and then also applies during the Bar Readers Course if anything arises during that time. So given that the interviews will be around that busy Christmas, January period, and some organisations may be closed for some period of time, it's probably best that you start preparing your documentation in respect to disclosures pretty soon after doing the exam. And that's particularly relevant if it's a disclosure that needs to go to the council committee. So the council committee is made up of members of our Bar Council, and they deal with issues arising with barristers and capacity to practice and fit and proper person issues, etc. So if your disclosure has to go to that committee, they will want to see as much material as possible, so you should make all endeavours to get that shortly after you've done the bar exam. It's important that the council committee have everything, because they are the body that will be recommending to the Bar Council whether or not you get a practising certificate. And if there is delay in getting material to them, that might affect your ability to start the course. So we try to make sure that they've got everything as soon as possible, so that there's no circumstances where you've passed the exam, resigned your employment, and then there's a decision, unfortunately, that you can't complete the course. So get everything together as soon as you can. It's probably an obvious point, but of course any material that you give to Rob or I, and any material that goes to the council committee remains confidential, and it remains only with the members of the council committee with whom Rob and I liaise, and in some circumstances members of the Readers Course committee. There's an issue that has arisen in the last couple of years. People have asked, what do I do if I've already disclosed things to, for example, the Board of Examiners or the LIV, and things like that. There is a paper that's been put on the website by Cameron Macaulay SC before he was appointed to the Supreme Court, and that paper deals with what barristers do in those specific circumstances. So I encourage you to have a look at that paper, particularly on the last page, and he deals with pre-the Legal Profession Act 2004 offences. So under the old Act, the disclosure regime was not as rigorous as it is under our current Act. And so whilst in the past you might not have been required to make certain disclosures, you might be required to make those disclosures now. So have a look at his paper, and then have a look at the relevant provisions of the Act if you're unsure as to whether or not something you didn't have to disclose in the past may now have to be disclosed. And certainly do that before coming to the interview. Just lastly, in terms of administration, Wendy beautifully organises the interviews, and there is some flexibility in terms of time. Often we have people whose employers have not yet been told that they're coming to the bar, and so we can make accommodations in terms of seeing you at lunchtime or after hours or before working hours or something like that. So there can be certainly flexibility with that. Rob and I just check that all of the paperwork you've completed has been completed properly, and we give you a copy of the undertaking. The last two things that would be great if you had arranged by the time you come to the interview. The first is a mentor. So your mentor has to have been at the bar for at least 10 years. Their 10-year birthday, per se, can occur during the Bar Readers Course, but it's something to bring to the attention of Rob or I, because there may need to be special provision made for that. But it's best to try to make endeavours to have a mentor by the time you come to the interview. And also best to start making applications for clerks. So sometimes it can be a bit tricky because each clerk has a different application process and different timing. But once you have passed the exam, it's best to start putting in those applications straight away, so that Rob and I can make a note of which clerk has accepted you or which clerk you have applications pending with. So I think that's probably all about the process and disclosures and the interview. If unsure, just disclose, and it can be dealt with promptly. So otherwise, good luck with the exam, and we'll see you next year.
Lovely to see you all here tonight. My name is Dr. Linda Heller, and I'm a senior lecturer at the Melbourne Law School and chief examiner of this entrance exam, and have been since it began. So this is our fourth exam, and I'm going to take you through what to expect in the exam. You've all got a general information sheet, so I'm just going to take you through that. So as David mentioned, the aim of the exam is to ensure that those admitted to the course have basic levels of competence and can demonstrate aptitude for the skills required of a barrister. And just to give you an idea of the overall features of the exam, and as far as I'm concerned, I think those of us who are involved with designing the exam would agree that these features have worked well. So it's a closed book exam, and I'll explain the beauty of a closed book exam shortly. Closed book, 3 hours in duration, preceded by a 15-minute perusal time. And as David mentioned, it covers the topics of both civil and criminal procedure, evidence and legal ethics. And there's a mixture of multiple choice and longer answers. And the pass mark is 75%. So I thought you'd be interested just in the breakdown of the questions in our most recent exam in May this year. It comprised 39 questions, and that was made up of 9 questions worth 1 mark each. So some of those might have been multiple choice, others might have just required a yes/no answer. 13 questions worth 2 marks, 8 worth 3, 6 worth 4, 1 worth 5 and 2 worth 6. And if you want to check your maths, I think that should add up to 100%. Now what we actually have been doing with all our exams, and this works extremely well I think, is that the exam comprises sometimes groups of questions that are linked by a common fact scenario. And these build up. So basically, instead of just throwing a large amount of text at you, a long hypothetical, and then ask a whole lot of questions, we build up this scenario. So for instance, you might be told a few facts at the stage of someone being brought for a committal hearing, a few questions around that, a few questions maybe around bail, and then the matter tracks through the court process. And different groups of questions like that you will see from time to time in the exam. So, for instance, in the most recent exam in May this year, that structure applied to questions 5 to 21, questions 22 to 33, and questions 35 to 37. So you can see that with one scenario, that you may stay with that scenario for a number of questions, and that's quite clearly flagged in the exam. In the general information sheet, you can see we've broken that up by topic area. So first civil procedure, criminal procedure, evidence and legal ethics. And if you just look at that list there, for instance, just on that first page in relation to civil procedure, you can see we're being quite modest. You can see that we indicate some orders that you need to be familiar with in relation to civil procedure, but there are a number of orders that we don't feel are necessary at this stage of your career as a barrister. And these are the topics on which to focus. And you can see for each area we give you a prescribed text, and you can see in some cases the prescribed text might not be as up to date as would be ideal. So for instance, the Richard Fox text on Victorian criminal procedure doesn't incorporate reference to the latest amendments in the Sentencing Act. And so for those, as you can see on page 3 of the general information, we expect you to go to the Judicial College's sentencing manual online to supplement what is in Fox on sentencing. All right, so for each area you've got a prescribed text. So for civil procedure, the prescribed text is Bailey and Arthur. Some of you might know that it used to be known as Williams on civil procedure. And there is a book, if you were looking for a more introductory text just to step into the Bailey and Arthur, you might want to have a look at a book that's published by the Law Institute bookshop, Richard Cook. There's a 2012 edition, Supreme and County Court Procedure. But that's only as an introductory step. The prescribed text is Bailey and Arthur. Now, important to be aware of the cases on the final page of the general information sheet. Now, if you look at the cases there, you'll see, for instance, there's one Legal Services Commissioner in Mullins, and that's coming from another jurisdiction, from Queensland, and you'll notice it's from the Legal Profession Tribunal. And there's other cases there that are single judge decisions. So they're not necessarily there because of their precedent value. Some of the cases are there because they provide some good examples of how the situations that barristers may find themselves in, from being cross-examining in court and not discharging obligations in relation to the rule in Brown and Dunn, for instance, various scenarios. So just be aware and read those cases carefully, because it's often those cases that inspire me as I'm coming up with fact scenarios. Those cases will sometimes be the source of that inspiration, and it certainly does become clear when marking the exam which candidates have spent some time looking at those cases, thinking about those cases. So what makes for a good answer? We're trying to test your understanding here through your demonstrated ability to apply the law and procedure and ethical rules in particular contexts. So that's a large reason why the exam is closed book. By being closed book, there's no temptation for you to just regurgitate Supreme Court rules and so on. It forces you to get into the application, and it's really in the application that we really do get a sense of whether you understand some of these principles. And that's where most marks will be allocated. How well has a principle been applied in a given context? And we certainly don't want you to be spending time rote learning section numbers or case names. We don't expect that. We also are happy for you to paraphrase principles of law, Supreme Court rules. Okay? By doing that, by paraphrasing, often that gives us a sense of actually whether you understand these things, and it certainly means that you've got more time to get into application, and then we really see whether you understand it. And so keep that focus, if I haven't emphasised it enough already, keep your focus on application, not simple recall or description. And we actually encourage concise answers. Sometimes the most impressive answers are the most concise. So let me take you through a couple of examples. So you might have a multiple choice question, and here's one, and you'll notice for each question it's clearly identified whether it's a criminal procedure question or a legal ethics question or an evidence question. That's always flagged at the beginning of the question. And this one's a criminal procedure question, and you're told always how many marks each question is worth. This is worth 1 mark. Which court will hear the trial? So you're given a set of facts. So this might even be one question amongst, say, 10 questions building through a particular case hypothetical. So you'd be given a set of facts and you'd be asked which court will hear the trial, and you would circle the correct answer. An example of a longer question, you would be given further facts and you would be asked about those facts, a criminal procedure question. On the facts provided above, what submissions could be made in support of X's application for bail pending trial? And to give you an example of what we would expect for a good answer, very applied to the facts we've given you. So a good answer would say something along the lines, submissions in support of granting bail could include X's lack of priors, cooperation with police, attendance at the committal hearing, that X has a stable place of residence. For instance, that is, he lives with, he might be living with his mother or sister and has done for so many years. So very specific to the facts we've given you. Also, you might gather from the facts that you've been given about X that there's a long-standing lack of contact between the complainant and X, and the alleged offence occurred many years ago. Right, so that's not a general sort of generic response. That's very working with the facts given. Another example. Now, you would have been given more facts than this, but in essence, the essence of the detail you would have been given would be that on the third day of trial, your instructing solicitor advises that they failed to include a letter in discovery. And the civil procedure question for 7 marks might ask, what submissions could you make to the court to increase the likelihood of the letter being now admitted into evidence? And again, very applied. Submissions for admission could include the letter is highly probative of. The client is willing to give undertakings as to costs if an adjournment is granted to allow X to seek advice regarding the letter. The letter was not discovered initially because, so from your preparation before the exam, you will realise that the court will sometimes want some explanation as to why the letter wasn't initially discovered. And again, a very practical issue, that X was not taken by surprise, as he is the author of the letter that was not discovered by our client, and so X should have discovered it as well. Now, in fact, this particular question about the barrister whose instructing solicitor failed to discover this particular letter, in fact, candidates on that, for that particular exam, on their reading list, there was a case where exactly that happened. All right, so if they've done their reading of those cases, they're in a much better position to get a sense of the options that were available and what submissions could have been made. Again, a question, more facts were given in this particular exam to set the scene a little bit. In essence, the problem was that the other side sent documents that appeared to be protected by privilege. And again, this was a question that was very much inspired by a question on a case on the reading list. And the legal ethics question asks, what should the recipient of these documents do? And a good answer would again be applying the law in a very practical way. The barrister should advise the instructing solicitors to notify the other side to see if they claim that the disclosure was deliberate or accidental, and if they intend to claim privilege. Quite likely it was accidental in this context given. So being informed by the facts earlier, this candidate is able to say that as part of giving the advice to my instructing solicitors, I would suggest to their solicitors that there is evidence that this was an accidental oversight. I would advise my instructing solicitors to advise the client of the situation and of the client's and lawyer's obligations regarding privilege. And while waiting for the other side's response, I would advise my instructing solicitors to keep the documents secure and not read them, as this could lead to restraint proceedings. So again, the candidates for this particular exam had a case to read where there had been inadvertent disclosure. An example of an evidence question. And this was placed again in a group of questions where a scene was building and a case was proceeding through court process. And the scene had been set for a Brown and Dunn challenge. Now, if there's some area that you really make sure you've got your head around, can I strongly suggest you understand the rule in Brown and Dunn. There are too many times when it appears barristers struggle with the rule in Brown and Dunn. And look at how this question is framed. It doesn't just require a candidate to parrot the rule in Brown and Dunn. That doesn't tell us anything about whether you understand it. The question asks, explain the rule in Brown and Dunn, its rationale and its application to the cross-examination of X. So this is exactly the person involved in the cross-examination at the time, the witness. So it's an application to the cross-examination of this particular witness, but you have to do it not in legalese, you have to do it in simple terms that a layperson is likely to understand. And certainly there's questions like that give us often quite a good sense of whether students have actually absorbed some of these principles. All right, and I think we were doing questions sort of all together.
Sure.
David, thank you.
Thank you, Linda. Are there any questions for any of us?
Yeah, I have a question for Linda. You mentioned that this is now the fourth, sorry,
Yes.
you mentioned this was now the fourth year?
Yes. No, fourth exam.
Beg your pardon, fourth exam, yes. Are there copies of past papers able to be checked or reviewed or?
No, there's not at this stage, no.
Look, are there circumstances where a mentor of less than 10 years experience would be considered or allowed?
There are. To use a very helpful word, exceptional. But recently that rule was waived in circumstances where the proposed mentor was an experienced English barrister who's a member of our bar. I think it's true to say in that case that barrister fell well short of the 10 years, but he had well over 10 years at the English bar and had been incredibly involved there. So there has to be something to warrant the exercise of that sort of discretion. We try not to be unhelpful. There is a reason for the rule. So I hope that's some sort of answer to you. It depends.
Is it possible for the person to be a silk or an afternoon?
They can't be still. There has been some, in the olden days, if your mentor took silk during the reading period, you had to depart forthwith from his or her chambers, but that rule's been relaxed so that you may stay until the end of the reading period. But no, it has to be someone of absent exceptional circumstances, at least 10 years and not silk.
Are you sticking with the 75%, 85% rule for this exam, or is it just 75%?
Well, until we're told otherwise, it's the former.
So the form being 75, 85?
Yeah. Does everyone understand what I mean?
No.
Sorry, there's the complete. The number of readers in the course is capped at 48. A logical possibility, let's just go back a step. The passing mark is 75%, as you've seen. Anyone who scores 85% or over is automatically into the course. If, as it may theoretically be possible, more than 48 candidates obtain a mark of 75% or more, there's a problem. And Bar Council's resolved that problem by saying that that number of candidates will be placed in a ballot and the requisite number drawn upon it. So when that gentleman asked me, are we sticking with the 75%, 85% dichotomy or rule, that's what he meant, and that's why I said the former, not the latter.
Just following on from that, should you pass but not receive a number in the ballot, what happens then?
Then you're placed in the next readers course. It's a question way up back there.
Is there a waiting list?
No. There was, but there isn't anymore.
Have you had the situation of the 75-85% occur in any of the past 4 exams?
Nowhere near it.
Okay. So fairly high statistical failure?
No. You assume that's the only possibility. It depends how many candidates sit the exam. So, I mean, what you say is a possibility, of course, but it does depend how many candidates sit the exam.
I have 2 questions, if possible. Just leading on from that, what's the sort of average percentage of people who get the 75% necessary?
I don't know the answer to that. I'm not even sure the specific answer would be very helpful, but I can say that what is apparent is that candidates who fail fairly convincingly, and do so, and I say so with respect because they don't and could not have prepared properly. Like any exam, read the curriculum. That's what the preparation is about, and there's a coincidence between curriculum and questions. Why that should surprise anybody is beyond me, but it does. Question B.
If you pass the exam and you sort of get a spot, is it possible to defer that to the next readers course?
It is, depending on the circumstances. I'll give a practical hypothetical example. If you are employed and there's a term of your employment that you are required to give, say, 6 months' notice, and having sought a dispensation for the 6 months because the time between being notified that you're in and starting course is less than 6 months, your employer says, we're not relieving you of your obligation. That is a basis for deferral. Saying that as a whim you've changed your mind probably isn't.
Just on the question of deferring, would mentor availability be something that could be taken into consideration in deferring? If your mentor says, for example, there's a 90% chance that I can know.
Sorry.
Okay.
As judges will often say, there are lots of good barristers out there, find another one.
Yeah, a couple of questions. In the exam, can you extrapolate on the facts at all? Like say, for instance, if X had a child, then we could submit this, but if that specifically isn't in the facts, did you not go there?
I think the answer to that question is yes, depending, but that's Linda's better.
Yes. Well, a lot of time goes into the exam questions, and I just don't think that would be necessary. I think, you've got enough facts to work with without complicating things. So, yeah, I think just work with the facts that you're given.
Oh, sorry, one more question. Sorry. Is the reading list or anything likely to change from the May exam, or?
If I were to guess, if it were to change, it would not be significantly. We tweak it from exam to exam, but...
Was that a question about changes from May?
To
this
the
one?
reading list.
To next May, I think it was.
Oh, do you mean for next?
For May 2013, yeah.
So I think tweaking is the answer to the question.
The reading regulations preclude practice other than as a barrister. Are there, would employment other than as a barrister, would employment other than practicing as a solicitor draw the ire of the committee? Would that be something which would be a problem?
It would.
Is it possible to hold on to foreign practicing certificates as a solicitor?
I don't believe not. Is it possible to hold on to a foreign practicing certificate?
Well, yeah, it doesn't entitle you to practice here in Victoria,
No.
so it's meaningless from our point of purposes, I would think.
Well, lots of people are admitted to foreign bars, but your question is about a current practicing certificate.
Yeah.
I suppose it's really a matter for the foreign jurisdiction, is it to their mind that you're in full-time practice here? If they don't, and you were not practicing there, then I can't see that the problem could arise.
No, I don't think so.
Sure. Yeah, I wasn't sure on the wording of what was in the guidance.
I don't have any particular words in my head, but if I'm, well, I don't think I can be wrong about that, because it's hard to see how problems could arise.
Yes, yeah, just to follow up to my last question. So,
But I answered so forcibly.
So therefore, if it's not precluded by the regulations, on what basis would the committee?
Well, it is precluded by the regulations, and you can't work as
No, other than practicing law.
The course itself is very intense and full-time, and we have had this question from time to time. Some people say, I'm a hairdresser, is it okay if I still cut hair on Saturday morning, make a bit of pocket money? And the answer is that we say it's really not ideal, because the expectation is during the 8 weeks of the course that really you're doing nothing but the course. But if you can fit in, or if you're doing babysitting or something, as long as you're not practicing as a lawyer or doing any legal work at all, yeah, but I wouldn't take on any job during that period that was going to be in any way time consuming, because you really won't have time.
I was thinking more in terms, not in terms of the readers course period, but subsequent to that.
Well, after that, I don't think there's any restriction on at all.
I wasn't sure whether the regulation applied in a continuing sense to your practice as a barrister, or whether it was just restricted to during the readers course period.
You certainly can't ever practice as a solicitor once you sign the bar roll.
Yeah, other than, I'm speaking other than practicing.
Yeah, as I say, if you're a hairdresser and you want to keep hairdressing while you're at the bar, I don't think there's any particular prohibition against that.
Thank you.
No, well, I'm glad that you did answer a follow-up question, because my answer might have been too
Excuse me, on the Allied question, I know you, just to confuse you more, it would be in terms of breaking out accumulated leave and holiday entitlements during the course. Are you allowed to keep that? Not attending, not doing anything, just having a good time on your holidays?
What? It's
not as a lawyer, in an unrelated matter, employment.
So unrelated employment.
So not as a lawyer attending the course, but still receiving a salary while you run out accrued benefits.
Yeah, that's fine. Everyone's nodding, that's kind.
And good luck.
Sounds like a pretty good gig, that.
Sorry, I just want to make sure I understand this. So if you're not practicing as a solicitor at the time, but you're engaged perhaps with ongoing obligations like company director positions, or lecturing in law, or something like that, how does that work? Because not everybody works as a private practice solicitor.
No, that's true.
Need permission. Need permission.
You what?
Need permission from the Readers Committee to lecture.
So that'd be one of the disclosure things
Yeah.
to discuss, or does that come right? You have that conversation before the interview?
At the interview.
At the interview, I think would be the appropriate time.
Right. Okay,
Yep.
thank you.
So that's for, because so everyone understands, that permission to, during the course,
Yes.
continue
To continue to lecture or teach on a part-time basis, and it would have to be after hours or weekend. It couldn't interfere with the attendance at the course.
Because that's one thing that we didn't mention, perhaps should have, that full-time, complete, punctual attendance at the course is an absolute requirement. So it's not, absent some convincing excuse, it's not open to you to arrive at 5 minutes past 9 when the course session starts at 9 o'clock. And absent appropriate type of illness or the like, it's not open to you not to attend for reasons such as you've mentioned or anything else.
No, but if you had a board meeting that commenced at 6 o'clock in the evening and this class finished at 5 and you sought and were given permission, that would be totally acceptable? Or?
It would be, once you have the permission. It would be.
Yeah, okay.
Yes, sir.
Practically, going about getting a mentor should, statistically be lucky enough to pass the exam. How does that work other than cold calling or knowing somebody?
How does it work? Really, your question is, how does it work if you don't know somebody?
Yeah.
Especially, there isn't really a system, is there, that's in place? Or
Well, we do. We do have a small number of barristers who volunteered to be mentors if you are absolutely stuck. And also you can approach some of the clerks. They can often help you with someone if you're looking for a mentor in a particular area of law. So the clerks are always good help. Or phone me, Wendy, and I do have a small list of people who are interested in being a mentor.
But most barristers would have no objection at all to being cold called to be asked to be a mentor at all, and there's often they would welcome it really. So
we have
don't have any
what we
hesitation.
call open door policy when you are a barrister, and that does extend to when you're contemplating being a barrister. You shouldn't, as Jacqueline says, you shouldn't have any hesitation at all in telephoning someone that you've never met or until you've called and never even heard of, and that they would be in almost all instances, I'm sure, quite flattered that you are calling.
When I arrived, there were no handouts. Do you understand?
No.
Everything will be put online tomorrow. So anyone who missed out, it's all online from tomorrow.
I've asked a question about the interviews.
Bree's got a spare, so I'm sorry.
Question about the interviews Bree was speaking about. Is she seriously anticipating doing interviews between Christmas and New Year?
No, immediately prior to Christmas and shortly after the New Year.
Another very good question. Yes.
What's the cost of the readers course?
$4,300. It's the application fee of $350 and then the course of $4,300.
So that's payable within a week of being accepted. Is that right?
It is.
It should come at any time.
Yeah,
So
hopefully before Christmas.
And of course, if the eventuality occurred that was contemplated in the question here, that you accept, you pay money, and then your employer says you're not going anywhere, well, then you can make that. It's credit to the next course or some arrangements made in that regard. No more questions? Well, I hope it's been helpful and encouraging to you all. We would encourage as many as you wish to keep that. So, good luck.